All right, welcome everybody. It's 4 o'clock. My name is Craig Miller. I'm one of the directors with the Federation of State Boards of Physical Therapy members there. I want to welcome you all to today's topic, First Amendment applicability to state regulatory boards. Our presenter today is Amigo Wade. He's the director of Virginia Division of Legislative Services. I think our topic is very important to issues going on today. Wanted to give you a little bit of information about Amigo here. He received his Juris Doctorate from Washington College of Law at American University. He has investigative experience, legislative experience, adjudication experience. He is known for providing many educational sessions as an instructor with the National Certified Investigator Training Program with the Council on Licensure, Enforcement, and Regulation, otherwise known as CLEAR. That may be a name that you hear coming up. We are honored and privileged to have Amigo here today with us to take us through this topic. As we go through the presentation today, you are welcome to add comments and or questions in the chat that's open and available to you. Otherwise, I encourage you to take notes for any questions, as we will save time at the end of the presentation for Amigo to address questions from the group. With that, I thank you for your time. I will hand it over to Amigo for the time being.
Thank you, Craig, and also thank you, Richard, for inviting me to participate in this series. Couple of things to start off with. Our objective today is to sort of give you sort of a healthy understanding of what some of the issues are in this area. So we're going to be at a very high level. We have a short period of time to go through things, so we'll be just doing sort of at the 30,000 foot level with strafing runs, so a lot of, if you ask some questions, my answer might be, it depends. And I think what I've always said is when a lawyer's answer is, it depends, that means that they don't know. So if I say it depends, then that means I don't know. And trust me on that. But if there's going to be any follow-up, I can certainly take care of that also if you have any follow-up questions. I think that this is sort of a novel area. It's something that a lot more regulatory boards are running into, in particular, since as we get to the portion where we're going through the most recent cases, we're seeing that the Supreme Court is sort of pivoting in terms of how they look at how regulatory boards regulate speech, regulate the speech of its licensees. So with that, I would like to tell people, having said that, with us being at a high level, I do have it on good authority from Craig and Richard that if you make it through this course, we're going to issue you an honorary law license to practice in any jurisdiction. Now, hold on to that, because I just exercised a free speech right. And I'm going to connect it in just a couple of slides why I can do that and still not be actionable. But I like to sort of give people a roadmap of what we're going to do with this hour that I have with you. I'm one of those people, when I'm driving in the car with my wife, I like to know, like, okay, what's the next turn? And I don't want her to tell me, now make a right when I get to it. I want to know a few blocks away. So I've broken this up into basically 4 components. The first component, we're going to sort of set the stage. I want to make sure that we're all talking about the same thing. What is the free speech clause? And also how the court goes about reviewing speech regulation when the aggrieved party has sought legal redress through the court system. Then I'm going to look at some implications for regulatory boards. What does this mean? And then we're going to spend some time sort of looking at some relevant case law, beginning with cases from 2017 going through 2025, to just show you how quickly, or not how quickly, but how recent the court's change of the view of how licensing or regulatory entities can regulate the speech of its licensees. And then we're going to look at a few key takeaways. And the objective would be to have some time at the end to be able to answer some questions with the caveat, remember that the answer might be, it depends. All right. So having said that, let's go ahead and get started. What is the free speech clause? It's basically it is in the First Amendment of the U.S. Constitution, and sort of the very quick background on that is that it was not in the Constitution, but a lot of states said, look, we'll pass the Constitution, but if you do that, you got to have these first 10 amendments because we don't trust you. And the first of those amendments was included the right to freedom of expression. So it doesn't just cover speech; it can cover conduct as well. And what it basically says is that it protects individuals and groups' right to freedom of expression from government interference. And we'll talk about what that means. I think that the starting point is going to be when we say the broadest tolerable exercise, what that means is that a core principle when the courts look at free speech regulation is that the government restriction should be as minimal as possible. It has to be sort of as closely connected in terms of regulatory bodies. It has to be as closely connected to the regulatory objective as possible. In other words, what do your standards of care say? What do your standards of practice say? The further you get away from that core regulatory imperative, the more you might get into trouble in terms of trying to regulate what that person or what that licensee can say. From a general time or frame, it's basically people. What this clause says is that people should be able to express openly on any topic without fear from government control or punishment. I think it's important to note that sometimes people don't quite understand. The freedom of speech protects you from government interference, doesn't protect you from a private, for instance, your homeowners association is not a government entity. They can tell you, hey, you cannot have signs in your yard. Now, some states have said, yeah, but you can have political signs. But just understand that it's the government, it's the government that has to be trying to limit your speech. So I like to use a couple of examples when it comes to just how extensive this speech protection is. The first one is falsity. That statement that I made just now about we're going to issue anyone who wants it a law degree, an honorary law degree to allow you to practice in their jurisdictions. The falsity alone of that statement does not make it actionable. You can't just say it was a false statement. You have to look at things that like it has to be knowingly made and it has to be reckless, and you have to look at the context. Also, the extent of this free speech clause is online speech, which is probably one of the more interesting things. How many of you are aware that with the advent of virtual testimony and being able to put things online, you have people that are sitting in the comfort of their living room or some other room in the house, and they're making statements online that they would not make if they were in a public setting. I see this with when we have virtual testimony for committee hearings. You have people that are saying things that I know they would not say if they were in that public committee meeting, if they were in person in that meeting. But what the court has said in 1997 in the case of Reno versus the ACLU is that online speech has the same protection as any other speech. Now, having said that there is, that it does protect speech, there are some instances or some types of speech that are not protected. It doesn't protect all categories. And here's some examples of unprotected speech. Speech that sort of is inciting imminent lawless action, of course, again, subjective. Fighting words, what do we mean by fighting words? Words that are either injurious by themselves or might trigger injurious behavior. And that can change and it can be subjective. When I was taking my bar review course back in the mid-'80s, I know there's nobody on that was around then. I had a law school professor who was teaching this bar review course, and he was in his late 70s, and he used as an example for fighting words. If somebody says, your mother swims after troop ships. Now, evidently, in the 50s, they were fighting words, but I don't know if they would be fighting words now. So it's very subjective, just in terms of what can be fighting words. Threats, and we're talking about true threats where you're looking at the intent and you match that with communication as well as the context. Obscenity, again, very unusual. I know that a lot of us are probably familiar with the statement, I know it when I see it, but that was a Supreme Court justice from 1964, Potter Stewart, and he was trying to give a definition of hardcore pornography. And what he said was, well, I know it when I see it. That's not a good standard, and it's not a legal standard there, but it's probably one of the more popular or famous statements that have been made. Child pornography, tortious conduct like defamation or invasion of privacy, as well as fraud. And what we're really talking about there is false advertising. So those are the types of speech that are not regulated. Now, I want to spend just a little time looking at how the courts review speech regulation. I want you to sort of look at it this way. How many of you are familiar with a deck of cards? Same deck of cards, 52 cards, 2 if you include the jokers. But with that same deck, you can play spades, you can play gin rummy, you can play poker, you can play I declare war, you can play goldfish or crazy eights. So what I want to talk about now is before taking a case, the courts have sort of set parameters in terms of a framework for how they're going to review what the lower court did or what the agency did. And these frameworks involve all the level of scrutiny. Now, when I talk about scrutiny, it's like how they're going to look at the case and how much deference they're going to give to the agency action as opposed to the individual's rights. Before I go into this slide, they're basically, courts have established basically 3 levels of scrutiny. And when we talk about scrutiny, it's like how it's how they're going, the level of critical observation or examination, the level of focus that they're going to give to that agency's action. The highest one is strict scrutiny, and that's usually involved when the government action infringes on a fundamental constitutional right, such as freedom of speech or the right to marry. The next level is called intermediate scrutiny, and that's less scrutiny. We'll spend more time talking about it. The lowest level is called the rational basis test. And that's basically if that is the test that is being used, the state or the agency wins every time. Now, for the rational basis test, the person who is going against the agency action has to prove that the agency action just does not have a rational basis, and that just is hard to do. But I want to spend more time looking at the highest level and the next highest level, because in those cases the burden is not on the individual that is aggrieved by the agency action. It is on the state to prove things. The first one involves strict scrutiny. That's where the state has the burden of proving that it has a compelling governmental interest. There is a compelling governmental interest, and that the regulation on that speech is narrowly tailored. And not only that, but that regulation has to be the least restrictive means of achieving that regulatory goal. So what you see in some of these cases is a lot of time is spent trying to get the court to not use strict scrutiny or to use some other. So you see, as you have a chance, because I know everyone after we finish this course after we finish this offering is going to go back and run to the internet and get copies of these cases and read them, so that you can make your application for your honorary law license. But you'll see that a lot of the initial arguments was, this is not strict scrutiny, this is a rational basis, or at least intermediate scrutiny, because most states know that if you get to that strict scrutiny, it's going to be very difficult to win. The next level is basically it's called intermediate scrutiny. And look at the difference between those two. It has to be a substantial government interest. Well, what is substantial as opposed to compelling? Words mean things when in these cases. The regulation has to also be narrowly tailored, but it doesn't necessarily have to be the least restrictive means. So that's a bit of an easier burden for the state to meet. And we're going to talk about some examples of how these levels of scrutiny are used in some cases. So now we know, when we're looking at the deck of cards, if the rules of review when it comes to cases that have been appealed to the court or have been presented to the court by someone that has been aggrieved by the agency or the licensing board's action, the court would first decide whether it's going to use strict scrutiny or whether it's going to be use intermediate scrutiny. Now, the next issue that I want to talk about when it comes to the court review of speech regulation is content versus content-based regulation versus content neutral. And I know it's getting a little, heavy and syrupy here, but I just want to make sure, as I said, our objective here is to expose you to the issues, give you a healthy understanding of them, not to make you so that lawyers have to eat too. I still want you to have to come to me to pay for legal advice but I just want to make sure that you understand these issues. So what is content-based regulation? It's basically laws or regulation where the topic of the regulation, the laws that are targeted, that target speech based on the topic that is being discussed or the idea or message that is being expressed. These are considered content-based or what they call viewpoint. And when we look at some of the examples, we see what's the difference between giving professional advice and providing a viewpoint. And I think that as we move further and further, we're going to look to see when does professional advice go, which is clearly within standards of care and the ability of a regulatory board to regulate. When does that professional advice move to become a viewpoint? And we're still trying to figure that out as we look at some of these cases. The important thing to note that when you have a content based regulation, it's presumed to be unconstitutional. And when I'm talking about regulation, I'm not really just talking about professional occupational regulation, but I'm talking about any government interference or attempt to regulate speech. And in those cases, it is going to be subject to strict scrutiny. A couple of examples of content-based regulation. A state's requirement that a pro-life crisis pregnancy center informs women how they may obtain abortions. That's considered to be content, so it's going to be viewed with strict scrutiny. Also, a town's ban on the use of sound trucks for political speech, even when the ban doesn't have any limits on the political viewpoints that have been expressed. Will you let the sound trucks be used for ice cream trucks? If it's going to be a ban, it has to be a total ban. You can't look at just the viewpoint. Now, the other type of regulation is what's called content neutral speech regulation, and what you're really talking about there, you're not looking at the viewpoint, you're not looking at the content, you're really looking at what we call the logistics of it, time, manner, with time, space, and manner. It will say something like noise ordinances, that they're between these hours. It doesn't matter what you're talking about. You cannot have loud, blaring music. Things like restrictions on the placement of signs. You can say where the government can say, well, look, someone might try to say, look, I want to put a sign that is 20 by 20 on my property to say that Amigo Wade should be elected as governor of Virginia. Well, reasonable time, place, and management. You can say, well, no, you can have the sign, but it has to be something where it won't interfere with people. And of course, you can see how good looking I am. If you have a picture of me, it's going to cause traffic problems. But you can have time, place, and manner restrictions that don't bother with the actual content, but just make it so that it's something that is manageable. What you're really talking about are controlling the logistical aspects of expression without regulating the actual message itself. So now we have sort of laid out. So now that you have these three levels of scrutiny. When it comes to free speech issues, you're likely going to be either strict scrutiny. The court's likely going to be using either strict scrutiny or it's going to be using intermediate scrutiny. Then when you look, if the regulation involves content-based regulation, then it's going to be strict scrutiny. If it involves content-neutral regulation, then it's likely going to be intermediate scrutiny. Now, what are the implications now that we understand like what the legal framework that's going to be used by courts in terms of, as all court cases are really Monday morning quarterbacking, and I make this point when I do the top 10 cases, as we look at these other cases, the regulatory boards that are involved each had good legal advice, and they thought that they were doing the right things. Sometimes you don't know until a court has made a decision on your specific set of facts as to whether what you did met or did not meet constitutional requirements. So from an overall standpoint, just looking at, okay, here's where we start from. States do have a compelling interest using their police power to control the practice of professions and occupations within their boundary. Of course, that comes from, as I said, the police power to protect the public health, safety, and welfare. And the easiest example to use, I can say, well, I spent several years watching the ER series, Chicago Hospital, Chicago Fire. I spent a lot of time watching. I think I might be able to perform some light operations. So I'm gonna go ahead and hang up a shingle to say that I am I'm able to practice medicine. What's the issue there? It's I may think that I have the right to do that, but you balance that right of the individual to do what they want to do as long as they don't adversely affect the rights of others with the state's police power and its interest in certain of protecting the public health, safety, and welfare. If I'm allowed to go out and perform operations when I haven't established that I've met the minimum standards of care and minimum standards of practice, minimum education, minimum training, then there's a high potential that I can hurt the public. And one of the points I want to make here is that, we have to remember in the regulatory arena, our starting point is, especially in a free society, is you start from the premise that, or the presumption that people can do whatever they want to do as long as they don't adversely affect the rights of others. So when it comes to regulations, sometimes, I think that I had a law school professor that explained it, that my right to swing my arms stops at your face. So much of regulation is finding that contact point and backing off just a little bit, to basically try to balance that individual's right to go into a useful occupation and the state's responsibility to protect its citizens. So now, once you have established that, okay, this activity needs to be regulated, and when we're talking about regulation, we're talking about minimum standards of care, minimum standards of practice. The for instance is when I passed the bar exam, the state was not saying, attention, here was Amigo Wade, the next F. Lee Bailey, the next Johnny Cochran, but it basically was saying that, look, we did everything we could to keep from letting Amigo loose on the populace. All we can say is that he meets the minimum standards, but once that happens, and once they have that ability over me, that authority is not all encompassing. Just because I am regulated by that licensing entity doesn't mean that licensing entity has full control over all the aspects of the licensed professionals, including that licensed professional speech. Having said that, what they're doing is the regulation is restricting certain speech by allowing it to be only to persons who are licensed. For instance, if your jurisdiction requires you to be licensed as an attorney, most jurisdictions do, then I cannot provide legal advice or represent someone unless I have met that licensing requirement. I did want to. I think we can check now to see if there are any questions about what we've covered so far. I know I said I would wait until the end, but I want to make sure I'm not losing anyone along.
Yep, no, that's right. I don't currently see any questions
Okay.
in the chat. I think, I guess one thing, if I'll just ask a quick question, is you mentioned that a lot of there's some subjectivity and maybe changing in views as time goes on. So we're just kind of thinking about, with the current climate out there with deregulation and that sort of thing, is that potentially something that may stand against us as board members going forward, just because there seems to be a view of trying to deregulate and maybe not have the significance of some of the board for regulation?
Well, so I think I think I understand what you're saying is that so when you're looking at your regulatory objective, I think what you're seeing with this with deregulation, and we're moving into an area where people are not presuming that government is doing the right thing, in particular with when it comes to regulating professions. You have to make sure that you stay as close as possible to the regulatory objective. For instance, and we'll see in one of the in one of the cases, regulating the doctor-patient relationship and what the doctor can tell the patient when it comes to meeting a standard of care is a little different in terms of, will you tell the doctor that he cannot tell the person that, hey, ivermectin might be a possible option to take. When you had some states saying you can't do that, it became a free speech issue. Is it advice or is it viewpoint? And we'll talk about that more when we look at some of the case examples.
Great.
All right. I know, what I'm gonna say, it depends. Okay, that's I get myself out of it. I think that if you look at traditional standard forms of regulation, you have the licensing requirements, you have requirements to ensure that people advertise, as well as making sure something is that they have malpractice insurance. And to do with what you're talking about, minimum standards of care in terms of how they go about the practice, minimum standards of practice, SOPs, as well as advertising regulations. And I think that's important. We have you want to make sure that the public is getting the right information. For instance, if you're a law firm and you try to advertise, or you have an advertisement that says that we can guarantee your result, that's probably going to be actionable, because that's where you can get into content-based regulation, because you cannot guarantee a result, as opposed to a law firm saying we have obtained the highest personal injury judgment ever issued or ever entered in the Commonwealth of Virginia. That's a fact. That's a factual statement. Or we are the largest law firm in the country. I think there's a law firm now that's going throughout the country saying we're the largest law firm in the United States. If that's true, it might make people say, hey, if they're a big law firm, then they can probably take on, big pharma or big other issues. So in those cases, you can have content-based regulation. I want to use as an illustration. You have you have a patient that comes in to see Dr. Jones, and he's complaining of back pain. Dr. Jones tells Samuel to go home and engage in a series of stretching exercises. Now, those stretching exercises under accepted medical practice create an unreasonable risk of damage to Samuel's back. So in the realm of regulatory oversight, Dr. Jones can be held liable by the state licensing board for the content of what he said, because that content did not meet a standard of care that was connected to the regulatory objective, which is making sure that you are giving proper medical advice. Not only that, he could have a civil suit brought about him, for basically malpractice. So that's sort of an example of where there can be content regulation, where there can be some sort of regulation of the speech that your licensees provide. But look at how close it is in terms of the regulatory objective. Now, the next thing that I wanted to talk about is sort of a lead-in to looking at where case law is sort of taking us. Since 1985 and probably going back to 1945, there was this concept of what was called professional speech, and that's basically speech that is based on expert knowledge or judgment, or something that is delivered within the confines of a professional relationship, and basically when I say, they call it the professional speech doctrine. It basically was something that said when it comes to professional speech, where they're either, where it's based on expert knowledge or judgment, or delivered within the confines of that professional relationship, this professional speech doctrine said that speech had less protection than other speeches. In other words, and I want to take this quote from the 1985 case. Basically, when a person is engaging in speech as a professional with a client, in that case, advice about securities, and he or she is engaging in the practice of the profession, and the speech is incidental to the conduct of the profession. Now, I say that because in a line of cases, not Supreme Court cases, but lower court cases, developed this sort of professional speech doctrine where courts would look at the ability of a regulatory board to regulate more in terms of that professional speech. The idea was that particular speech, it basically gave states more power to regulate the speech of licensees through professional and occupational licensing regimes. And that was something that what we're going to look at when we look at this line of cases. That is something that has changed a lot as we look at how the Supreme Court and other courts have begun to say, wait a minute, what is this professional speech doctrine? Because what's important is that it wasn't. I cite the case of Lowe versus the Security Exchange Commission. It wasn't a part of the actual case decision. It was in a concurring opinion that Justice Byron White had. So it's sort of this sort of cottage doctrine has been created by lower courts that have led to this idea that professional speech has less protection under the First Amendment protection umbrella, if that makes sense. Now, let's look at some cases. Again, we'll be looking, we'll be at a very high level. I'm going to look at 6 cases, beginning with 2017, and you'll see in these cases as how they have sort of combined to turn away from this doctrine of professional speech to basically saying professional speech gets accorded the same amount of speech, or the same amount of protection as any other speech. Let's begin with the case of Woolslager versus Florida. Basically, Florida had a law that prohibited physicians or licensed doctors from inquiring or counseling patients on firearms ownership and safety. Now, with the court, compare that with the example that I gave, where the physician gave the patient specific medical advice about stretching exercises. You see how it's very connected to the regulatory objective. If you look at this, it goes a bit beyond, medical advice. It's talking about basically providing counseling on firearms ownership and safety. And what the court said that the act was content-based, was a content-based restriction on speech. And because of that, they looked at it using strict scrutiny, and they said that it infringed on the physician's First Amendment rights by interfering with the doctor-patient relationship. And I think it sort of highlights the issue when we try to regulate or get into the middle of regulating that doctor-patient communication. And in this case, it's sort of, yes, it did probably go beyond. You could make the argument that it went beyond just giving medical advice, but it still was too far away from the regulatory objective. Now, this next case is probably the most important one in terms of the pivot away from this doctrine of professional free speech. It's the National Institute of Family and Life Advocates versus Becerra. You had a state law that required licensed centers to post visible notices on that other options for pregnancy are available from state-sponsored clinics. The basically the court found that the state board limitations on speech were only justified in a couple of instances. But before I get to that, it the main thing that the case did was it rejected all this discussion of the professional speech doctrine, and basically said that professional speech is basically was not recognized as a separate category of speech, that it had the same protections as any other speech. And I think what's important to note is that the court said that state board limitations on speech were only justified where the limitation was either one of two things: either it was a requirement to provide purely factual, uncontroversial, and uncontroversial information about the terms under which the services would be available, or it was a professional regulation that was only incidental or only incidentally burdened speech. And in that case, it did not find either of those things. It basically said that the government regulations amounted to compelled speech, which are viewed under strict scrutiny, and it did not meet, and it failed to pass that test. So with this case, you have basically the pivot away from this idea that licensing boards had more authority to regulate professional speech or the speech of its licensees, and to turn away from that, to start saying that no, it's the same amount of speech that should be, that speech has the same amount of protections as any other speech. It basically was saying just because you have a licensing regime that is involved, and just because you're licensed by that board, doesn't mean that you lose any of your free speech rights. Of course, again, staying as close as possible to the regulatory objectives. To keep thinking about that example that I used with the stretching exercises, as opposed to in this case, where you are compelling additional speech beyond that. Now, the next case, Visalign versus the Mississippi Board of Licensing for Professional Engineers and Land Surveyors, is a 2020 case. I think it's important. Well, first, what the case involves. This is sort of the brave new world. What the company did was it converted existing meets and bounds descriptions that were that of real property that you can find at going down to any courthouse, and turning that into maps using a computer program. I'm sure that AI is involved, and I don't mean Allen Iverson. And what the Supreme Court, what the Mississippi Board said, that this really involved engaging into the practice of land surveying without a license. What I think is important to note is that the Mississippi case, I'm sorry, the Mississippi court referenced the NIFLA case, which had just been passed, and said that basically the Supreme Court had recently disavowed the notion that occupational licensing regulations are exempt from First Amendment scrutiny. So they reaffirmed that. It also said that in overturning the professional speech doctrine that had been deployed by some of the lower level courts, some of the circuit and some of the appellate courts, the court rejected the theory that gives states, but what this court said was, and this is the quote, that gives states the unfettered power to reduce a group's First Amendment rights by simply imposing a licensing requirement. Again, the relevant question in this court's view is whether the Mississippi licensing requirements regulated only speech, restricted that speech only incidentally to their regulation of non-expressive professional conduct, which basically means was their regulation incidental to the free speech right? And in this case, they didn't overturn the case, but they said basically that the lower court did not use the right framework for making its decision. So they sent it back to that lower court to say, you need to look to see, did the licensing requirements only incidentally burden free speech? So the jury is still out on that one. Now The next case is Del Castillo versus Florida. Miss Del Castillo was owned and operated what was called a health coaching business, which involved giving people dietary and nutritional advice. And she began the business in Florida, and in Florida you did not have to have a license to provide this type of dietary advice. And that's, I think, the point to make there is that, especially in the U.S. jurisdictions, choose different ways to regulate, and they choose different activities to regulate. And in this situation, providing providing nutritional or dietary advice it was required to be licensed in California. Most people say everything has to have a license in California, but in Florida it was not required. So this person moved from California to Florida and began and continued to conduct business as someone as a nutritional and dietary advisor. As I said, Florida does regulate what it calls dietetics and nutrition counseling through a state act called the Dietetics and Nutrition Practice Act, which basically says that no person can engage in those activities for remuneration, for money, without being licensed. And in this case, what the court again, helped to define, well, what can be regulated. And what the court said was that although the NIFLA court had really declined to recognize this professional speech doctrine as a unique category of speech that is exempt from the ordinary way that they would review first speech regulation. It did reaffirm that the state can regulate professional conduct if that regulation and if that conduct is incidentally involve speech. So in this case, the actual Practice Act was upheld, because what she was saying is, you are infringing on my free speech rights by not letting me give people dietary advice. So they're beginning to draw the line as to where states do have a right to regulate. But again, it's in the context of there's no professional speech doctrine that gives states more authority to regulate speech. Now, the next case is Stock versus Gray. And this is and this comes out of Missouri. There was a law there that basically it forbade pharmacists from contacting the prescribing doctor or patient to basically dispute the efficacy. I want to use a big word today, so efficacy. It's hard to sound tough when you say efficacy. But of ivermectin tablets or well, you know the word.
Hydroxychloroquine. Yeah.
Hydroxychloroquine. Yeah, well,
They're close enough.
That's why I didn't become a doctor, is because I couldn't get basically what it forbade doctors from doing was say, I'm sorry, if I was a pharmacist and I got a prescription from a doctor for ivermectin, then I would call that doctor and say, hey, you really shouldn't be prescribing this. So what the law said is that you can't do that unless the doctor or the patient asks the pharmacist. So it's basically saying you can't do it on your own, but if the doctor or the patient asks you, then you can look into it. So what Stock said was that the law unconstitutionally restricted him and other pharmacists. He was doing it on behalf of other pharmacists. Speech based on their viewpoint. So here again, that's where you get into, okay, is it medical advice? Is it pharmaceutical advice, or is it viewpoint? Basically, he asserted in the first instance, the court granted a preliminary injunction which kept the state from enforcing the law. basically what he was claiming was that the law violated her First Amendment rights by restricting her ability to provide information about those two drugs, and the laws, what she thought was the law's disparate treatment of pharmacists based on whether they wanted to discuss the drugs unapproved uses or other approved uses, and she felt that that violated the free speech clause. So the court was convinced enough to issue a preliminary injunction, and I looked to see, and on the 28th of March 2025, the court permanently enjoined the Missouri Board of Pharmacy from reviewing, investigating, prosecuting, adjudicating or enforcing that act. So that's a permanent injunction. So that's a situation, again, trying to compare it to the first example that I gave with the stretching advice. You're getting into viewpoint advice. So hopefully you're beginning to see some of, where we're getting to the razor's edge of what agencies can and can't do. The last case that we're going to talk about is one from 2025, and this is Cajano versus the Duval County School Board, and it's from, as I said, from 2025. So just to provide more background, and I have some some understanding of it, because I think sort of the same thing happened in terms of developing my first Facebook page. I did it with my daughter about 20 years ago, and and I haven't used it since then. In the case of Cajano, he set up his Facebook file, his Facebook account with his daughter in 2008, and he never used it. He thought that it was set to be a private post, so he didn't think it was being posted publicly. 12 years goes by, and then the 2020 presidential election comes up, and he made several posts and reposts on his X page or Facebook page that were political in nature, but they were also had to do with violence toward women, child abuse, and some other instances. And as I said, he said that he thought that his account was set to be private, and that someone hacked into his account and made it public. But at any rate, they were made public. I think it's interesting to note that it wasn't a school-related Facebook page. It was his personal page, but some other educators were included in his friends group, so they were able to see the post. Someone informed the school board, and the school board initiated an investigation. That investigation found basically that there were 7 posts that they thought were actionable. So they had a 4-day evidentiary hearing where they heard 16 witnesses before an administrative law judge. The administrative law judge, of the 7 posts, he said 2 of them concerned either violence and abuse of a child, and discriminatory and degrading views of women being abused and raped. And with those being actionable, the hearing officer recommended a written reprimand and a 3-day suspension without pay. Cajano appealed, and he asserted that the suspension and reprimand, that action violated his free speech rights because he was acting as an individual. He pointed out that he didn't use school resources. There were no communications or any contact with any of the students. There were no improper or defamatory statements about the school district or the school administrators or teachers or other students, and it did not involve matters of school administration. What the court said in that case was that Cajano's free speech rights were violated, and what they pointed to was the fact that he didn't use any school resources. He did these things on his own time, and it did not involve any of the school administration. I think that what they did in that case was they balanced the person's ability to be able to freely express themselves they balanced that against the school board's interest in running a running an efficient school district. And they said that in that balancing test, his rights to free expression were overcame the school's right to efficient administration of the school district, of course, citing that he didn't use any school resources and things of that nature. So those are the 6 cases that I wanted to kind of go over with you so you can see where we're pivoting into a time where it's not just enough to say, okay, you are a licensee of this board. You have to be more intentional about looking at how we regulate speech. So here's some of the takeaways. As I said, because of NIFLA, courts are going to be looking more specifically. Just because someone is a licensee within your regulatory authority, that authority to regulate is not all encompassing, especially when it comes to their speech. I think it's going to take additional litigation to make it clear what the parameters are. And my advice would be, that you first have to ask yourself, what is the regulatory objective? What is the standard of care that we're trying to meet? Are we looking at viewpoint regulation, or are we looking at established medically accepted practices in the medical field, and whatever the standard accepted practices are in any professional field of endeavor. And then the question would be, unless the speech limiting regulations only incidentally burden speech, or are narrowly tailored to advance, again, that compelling government interest, then they're likely going to be found to be unconstitutional. So with that, I think that I've left some time for some questions if people have them.
Yes, Amigo. So first of all, thank you very, very much for giving us all an honorary law degree. I heard that's what you said in the beginning. So I appreciate that. I'm ready to take the bar. So a couple questions did come in. So if you could address them. One of the questions related to the Stock v. Gray case, and just asked if you could clarify. So can a pharmacist reach out to physicians in the absence of, like you said, either the physician initiating it or the patient initiating? Can the pharmacist reach out to a physician? What was the outcome?
Well, the outcome was, so what the law said was that the pharmacist couldn't do it, and he got the preliminary injunction, and then he got the permanent injunction. So in Missouri now, the pharmacist can reach out to the doctor.
And is that because of the injunction itself, or was there a separate rule or legislation that had to be passed to allow that?
That was because of the injunction itself. It basically, it's, when you have a permanent injunction like that, the law may still be on the books, but the pharmacy board in Missouri could not enforce it.
Gotcha. Thank you. Yes, I think that's the comment was that we could see implications for PT practice if that we weren't allowed to follow up with a physician if it wasn't something that was initiated by a patient because of something we may be concerned about. So.
And I think what seems to be happening more and is that because of the way things are sort of moving, as we came out of COVID, what some boards are trying to do really get into regulating viewpoint. I don't agree with that viewpoint, so we're going to prohibit you from espousing that viewpoint. And when it comes to that doctor-patient or that professional-client relationship, and I think that's where some regulatory bodies are getting into trouble, especially with the way that the courts are looking at speech regulation.
Thank you.
Thank you, Amigo. I wondered about the impetus for that as well. So thank you for that background.
Okay. Yeah. So I mean, I think if you look at the cases that I included to really talk about, it's because cases make case law, and you have if you look at the issues the way it involved, abortion rights, where you have some states saying, okay, you have to give information about, or when you're saying, it usually involves controversial issues. I know that some of us can remember what some doctors said about ivermectin, and whether it was, where the licensing boards were trying to get into the fray and say you cannot have that viewpoint, and if you look at the way things are moving now with some of the more controversial issues, I think that, with people appealing them and them going to the court system, they're getting they're giving the Supreme Court the ability to sort of weigh in. And that has resulted in what I think is a weakening of rights that of the right that boards have in terms of being able to regulate speech.
Thank you, Amigo. Another question that was in there was the Cajano versus Duval. Did Cajano identify himself to be an educator? If not, and he had identified himself as an educator, would it have impacted the outcome of the case? I guess so. Is there a context there that matters?
So in terms of, he did not identify himself as an educator, but the people that saw the post were other educators and they knew him as an educator. So as to whether there was a factor, it looks like what the court looked at more was, did you use school resources? Were you on school time? Were you on your own time? Did you say anything to students? Did you make any derogatory remarks about the school administration? It just saw no tether between what he said and the school's ability to run an efficient, school district. So I think that was, I don't think, he also tried to say that, hey, I didn't mean for these statements to be, public. They were meant to be private, but that didn't really help him. I think what the court looked at was, what was the context that what did you use? I think it would have been different if he used, if he was on school time, if he used school resources, and if he said something like, yeah, our own school administration, is if he brought that in, then okay, then that, then that would have given the school district more power or more authority over him, because now this is an employee that's talking about us. And I think, what was the second part of that question? I think you said, did he identify himself as a teacher?
If he had identified himself as an educator, would that have impacted the outcome of the case?
I think it would have been one of the things that he was charged with was something akin to bringing disrepute on the teaching profession, and so it's one of those things. Okay, there are lots of us that may have a viewpoint, but in our professional lives, like, we don't make them known. But if you start, I think it's one of those things where boards can also get in trouble if you say, well, your viewpoint, has caused, damage to the profession because people don't think as well of us because of you. I think that's sort of a danger zone. But yeah.
Thank you.
No,
I appreciate that, Michelle. Hopefully that did answer your question. We'll give it a moment to see. We have a couple minutes left. I'll give it a moment to see if another question comes in. I did post in there reminder to everybody that we do have also upcoming regulatory hour webinars. One more here in September, one in October, November, and December. And also, if you are not attending the annual education meeting in person, you can register and still listen and participate in key presentations virtually. So hopefully you do that. I don't see any other questions, but Amigo, I have a question for you.
Okay.
So kind of going back to that, you had I think Wolshager versus Florida discussion about the gun ownership. Kind of similar to the last question, had the individual physician working with that particular patient, if they had been like a psychiatrist dealing with depression or that sort of suicidal ideations, or even harm to other people, could that have had an impact on that outcome because of a context?
I think it would have, because I mean, it's, you know, if you're a, general practitioner, medical professional, is talking about, well, to put it another way, if you're, if you're talking to your psychiatrist, you know, and about issues that you might have, I can see where it's more likely that a part of going of practice, you know, in terms of that psychiatrist treating you, can get into issues that may, well, let's, maybe you shouldn't have a gun around the house, or maybe, what makes you think that you need to have a gun? I think that would have been, I think that the decision may have been different, but this was a general practitioner who was, was he getting sort of outside of his wheelhouse? Yeah, I think it would have been. I mean, I think it depends on what the person is licensed to practice as.
No, thank you. I know we have an upcoming webinar on, PTs practicing in the health and wellness sector. So, again, kind of that whole advice viewpoint, I can see where there can be some important clarifications there. So I appreciate it. With that, I know we've reached our 5 o'clock time frame. Amigo, again, I want to thank you on behalf of the Federation and all the individuals that attended today. I think we can all definitely say we are not ready for the bar at this point. But again, maybe it just depends. So I appreciate it very much. Okay.
Okay, thank you guys, and I appreciate y'all inviting me. And if anyone has any other questions, I think that that Richard and Craig have my information. So just go ahead and send it to me, and the answer might be it depends, but you will get an answer.
Thank you, sir.
All right, thank y'all.
Bye-bye.